Uh, a wonderful day to one and all of you. My name is Dr. Chanjana Elsa Philip, and I'm an Associate Professor at CEERA University School of Legal Studies. Through this video, I will be discussing on the law relating to the First Information Report, which is otherwise commonly known as FIR. Now, this video is under the Pan-India Legal Literacy and Legal Awareness Program conducted by CEERA-NLSIU under the aegis of Department of Justice, Government of India. Indeed, it's a pleasure to give this lecture on this platform. To move on with the topic that has been provided today, we would be looking at what an First Information Report is. Now, as we all know, we have the Code of Criminal Procedure, which deals with the First Information Report. Now, that's not a definition which is given there, but it is only telling you how should that particular procedure be when you're coming up with an information. Now, the section specifically tells you that it should be a cognizable offense. That means it should be something which is a serious offense for which your punishment is generally about, for which it is about 2 years. Now, for an FIR, this information that you take to the police officer should reflect. So whatever information that you are giving should reflect that it is a cognizable offense. That means it is a serious offense. And other criteria is you can either give it orally or you can give it in writing. Now, if you're giving it in oral, then the station house officer has the responsibility of putting it to writing. And another change that has come is that this should be given free of cost to the person or to the informant who is coming with us. So this is what 154 clause 1 of the CRPC tells you about. Now, the whole thing 154 tells you about. So this information that you take to the station house officer should be in relation to something which is of a cognizable offense. It can be written or oral, and it has to be given free of cost. Now, at the same time, when we speak about this, these are the terms which are used interchangeably many a times, but that is FIR and complaint. You file. Now, what happens is you take a complaint generally according to the law, according to the CRPC. What you take to a police station is only information. Now, based on the information, the police will prepare an FIR based on the complaint that you have given. Now, that is why it is said that complaint that you give can be either written or it can be taken up orally. However, there is one more concept that the CRPC covers, which is called a complaint. Now, there is a slight difference in this complaint and FIR. When I said that the FIR is that what you take or the information that you take to the police station or to the police officer. Now, complaint is something which has been defined under section 2 clause D, and complaint, there is a procedure from section 200 of the CRPC, and complaint is what you take to the magistrate. Now, in that complaint that you take to the magistrate, you can directly take it to the magistrate, and you can write, you can give an oral or a writing to the magistrate. And why you're giving this to the magistrate is you have the intention that it should be an action which is taken. You want an action to be taken, but however, it will not be a police report because you have not taken it to the police station. You have taken it to the magistrate directly with an intention that the magistrate should take up this matter seriously and look into it. So this can be given orally or in writing, but generally a complaint is given in writing. So these are this FIR and complaint are the two things which we generally use interchange and use. But FIR, as I said, is to the police station and information which you carry, which can be. But then as far as a complaint is concerned, that goes directly to the magistrate. So I just want to put forth to you what would be the differences between, major differences between a complaint and an FIR. Now, a complaint is in fact a non-cognizable offense. Generally, it is a non-cognizable offense. But whereas an FIR is a cognizable offense because it's an information that you're giving regarding a cognizable offense. Now, a complaint is always filed before the magistrate. You can directly go and file it before the magistrate if you feel the involvement of the police is not needed. Now, as far as an FIR is always taken to the police officer directly, it is taken to the police station directly. Now, as far as a complaint, as far as a FIR is concerned, With the lodging of the FIR, investigation starts. But then for a complaint, now complaint when you give, the problem is it is not necessarily only non-cognizable offenses. It can be something serious. It can be a cognizable offense also when it is a complaint. But then the problem is that if sometimes the magistrate feels that there should be further inquiry into the matter, then the magistrate, even before proceeding, what the magistrate does is the magistrate will give an order to the police to do an inquiry about that matter. So once this magistrate gives an order to the police to inquire and let us know what exactly has happened, or what is the base of this complaint that I have taken to the magistrate, the police will start its investigation. If the magistrate has asked the police to do an investigation, obviously we cannot come back unless and until under 154 the police will file an FIR, the police will do an investigation, and the police submits its investigation report. So that is left to the magistrate. That depends upon the facts of the complaint or the matter of the complaint that you have written and submitted before the magistrate. Because if it is something which is serious, then the magistrate will have to take further actions. So that is the reason why under these circumstances, the magistrate will have to look into whether how serious the offense is, or if the magistrate feels, no, it's just not a complaint. You can't just go with a complaint. There should be a further investigation. Then the magistrate will order for a further investigation, and the matter is taken up thereafter from the by the police from that stage onwards. And if the police has taken up that matter, then it will take the circle of launching an FIR, and then an investigation, a thorough investigation will be done, and it will end up in what we call as an investigation report, which will be submitted to the magistrate. And based on this investigation report, if it is a cognizable serious offense, based on what the report has been given, then it will be a trial accordingly. But otherwise, if it is not a cognizable offense, or if the magistrate feels that it need not be referred to the police, it is a matter which can be dealt with by the magistrate itself, then the magistrate will not refer it to the police, and the magistrate will issue summons to the opposite party, and then there is a trial which happens under the CRPC. So there the procedure or the time that is taken can be reduced. You won't have to wait for the investigation report to come, and the police will not have much of a say there. That is because it is something which you have directly given to the magistrate, and magistrate has taken cognizance of the offense. Taken cognizance only means taking note of the offense. So that's like a procedure wherein the magistrate says, yes, I accept, I understand that there is a case. So that's the legal terminology which is used, taking cognizance of the offense. However, if the magistrate feels the matter is serious, not to forget that the matter will be referred to the police. So this is basically the difference between an FIR and a complaint. Now, particularly, there are a few changes which has happened. So we only know the technical or the traditional way of how we go to a police station and we file an FIR into the police station. But then, there are many times in practicality, when you go to a police station, the police might wash his hands off saying that, this is not the jurisdiction where you need to come. This police does not have the authority to take up this case within within their limits. So this comes under the limit of some other jurisdiction. So the police might refer you to that particular police station. But now, particularly after the Nirbhaya case, now there was a particular committee which the government had formulated, and that was called the Justice Verma Committee Report. So there were a lot of changes which were suggested. Out of a few were like particularly with regard to women, what protection has to be given, increase in the punishment with regard to sexual offenses. So all these were changes. Now, a few important changes which that has been discussed or that has been brought through and which has been incorporated in the law is with regard to two things. One is zero FIR and online FIR. Now, we only know this traditional concept of going to a police station and filing an FIR to the police there. Now, what happens is many times when you approach a police station and when you ask for a complaint to be taken up, the police would tell you that we don't have the jurisdiction We don't have the power to take up your matter. This, what has happened, is not within our jurisdiction. It is to another police station which has got another jurisdiction, which has got jurisdiction to deal with the matter, and we will not interfere. Now, this is something which has happened very commonly and even now. So, particularly after the Nirbhaya case, there was this committee which was formulated, which is called the Justice Verma Committee. That was in 2013. They submitted the report. So they recommended a lot of changes which is to happen. Now, a lot of changes in the sense with regard to sexual offences, how much of punishment, the increase, the hike in the punishment that is to be given, then what other facilities can be given to a complainant when he's coming and lodging an FIR to a police station. So there were discussions, and there was a report which was submitted with quite a few reforms which were to be brought in. Now, there are these two concepts which I would like to discuss, which is online FIR and zero FIR. Now, let me tell you, zero FIR is not a terminology which is being used. Now, what it says is, now what exactly that you mean by a zero FIR is, nowadays, the police cannot reject any complaint on the ground that they don't have the jurisdiction to take up the matter. Now, it says that every individual, if you are able to register an FIR at any police station, it has no jurisdiction issues at any police station, irrespective of the jurisdiction. So that is one of the changes which has happened. That is exactly what we mean by this concept called zero FIR. But then zero FIR is the terminology that has been generally used. But otherwise, what it says is, without jurisdictional issues, any person should be able to take up, any police officer should be able to take up a complaint which is being registered. Now, at the same time, you also have the issue of an online FIR. So would you be able to file an online FIR? Is it necessary that you should be going to the police station directly and only then can you file an FIR? Now the law, after this particular committee report and all was submitted, now you will not find much of a change in the law as such. Now, these are concepts which have been upheld by the court through various decisions as well. Now, here again, the law says that sufficient changes are made in wherein instructions are given, guidelines are being formulated, asking the policemen to take FIRs online. So such arrangements, so there are guidelines given by saying that how do you take it up? So you need to take up any FIR which is lodged online. So you get the facility to file an FIR online as well, and a copy of this will be, now that particular jurisdictional police will be given the power to find out and whether it falls within their jurisdiction, and accordingly they will see to it that a copy of it is given to the person, that they see to it that the person or the complainant gets a copy of the FIR that has been filed online too. So so these were two major things that have happened in this particular area of first information report. One is zero FIR, telling you that yes, you can file an FIR, you can take up a complaint before any police station, irrespective of the jurisdiction. You can go to any police station. The police cannot reject it, saying that he does not have the jurisdiction or they don't have the jurisdiction to take up the matter. They will have to accept it, and then they will have to do the needful. So at the same time, you also have the online facility of filing an FIR. Now that also has to be taken care of. Now you can file an FIR online, and there a copy of it to make sure that has reached. Now there you will get a copy of the FIR that is being filed. Now the next concept, that is which is generally interchanged and used wrongly, are two terminologies. One is again FIR and charge sheet. Now, charge sheet or challan was a terminology which was used much before, in the presidency courts. It has not been used now. To tell you, now I told you about FIR being filed before a police station. Now, after that, once it is filed before the police station, the police will do an investigation. Now, police will go to people in that area, or police will call those people who are acquainted with the facts and circumstances of the case, and the police will question them, and accordingly, the police will prepare a particular statement for each person, what they have given. Apart from this, there will be other evidences, other circumstantial evidences which the police will find out. Now, based on all this, the police will submit an investigation report. That means a completion of the investigation report under section 173. That is, when you started the FIR from 154, in between it's only telling about the procedure of how the police should follow and do the investigation. And finally, the police will submit its investigation report. Now, this is generally called the completion report. Now, what this contains are those grounds which the court can look into and frame a charge. So that means the police doesn't frame the charge. The police submits this completion report, which is otherwise called the investigation report, to the court, telling court, I have completed my job, I have done my job. So there, the court will take up the matter, and the court will go through the investigation report, and the court will frame charge against the accused. Now, because that report gives a ground for the court to frame a charge, that is generally called as a charge sheet. But a charge sheet has nothing to do with an FIR. FIR will be part of that completion report. FIR will also be there. Other evidences will be there. So all this put together will form that investigation or completion report, which in colloquial terms, which is used as charge sheet. Now, this was why it does not change, is because that was a terminology which was used during the British period in the presidency courts. That's the reason. But otherwise, the police doesn't frame the charge. Police will only complete its investigation and take the matter to the judge to take it up. So thereby, these were a few concepts which I wanted to share with you all. One was with regard to FIR, the difference between an FIR and a complaint. FIR is always a serious cognizable offense, which is always filed to the police officer, police station. And second was a complaint, which you can take the matter directly without the intervention of the police. You can take it directly to the magistrate. But if the magistrate feels that the matter has to be looked into, magistrate might order the police to look into the matter, which the magistrate will, where the police will have to report back, but that will be through an FIR and investigation, and submits it. Then there were a few concepts which I wanted to tell you. One was importantly with regard to where do you file an FIR. Now, there are no issues with regard to the jurisdiction of the police station. You can file it in any police station that you want. It is the duty of the police to see to it that the necessary information is reached to that particular police station, and the FIR has been filed properly and the procedure has been followed. Also, you can file an online FIR which is being permitted, and a copy of it will be seen to it that it reaches the person. Now, also this FIR can be done in local language itself. There are no restrictions. What you feel, what is your local language is how you can give the information regarding. Another term or another concept was a charge sheet. Charge sheet is not no relationship with FIR. Charge sheet is a complete investigation report which has been submitted by the police after the FIR investigation, questioning, everything is over. That what is filed, and FIR is just a first step towards investigation. So, and otherwise the charges are being framed and filed by the police. So I think I was able to give you a view on what a first information report is and how do we go ahead with that. I thank the organizers for having given me this opportunity. Thank you. Thank you so much.